Okay, so our last few Chevron topics are sort of miscellaneous points, but they're important. They're both pretty controversial these days. And so the first one is a timing puzzle, which is if you have a statute that is ambiguous and a court interprets it when an agency hasn't done anything, can the agency come along later and adopt a different interpretation? And so if you think back to Chevron, for instance, there the EPA had adopted this narrow interpretation of stationary source that said, each individual unit counted as a separate source of air pollution. And then later the agency came along and changed it to this bubble interpretation that is broader, that encompassed multiple sources within one facility as a stationary source. So what if instead of that fact pattern, we had the first interpretation coming from a court, and then later the agency tried to come along and change the governing interpretation? Is that something where the agency has that power, or does the court's interpretation lock it in? And so that's the question in Brand X, which is another case on everyone's favorite topic, telecom regulation, right?
Okay.
And so for this, we've got Ms. Deneen, Mr. Gluck, Ms. Kuntz, and Mr. Willie. How are you guys doing? Are you around?
Here.
Yep.
Chris, I see Jeffrey. I
Yep.
heard someone, but I'm having trouble finding you. I see Mary there. Okay, cool. And Danielle?
Yeah, I'm here.
Oh, there you are. Okay, cool. So what's going on here? What's the agency and the statute and so forth?
The agency is the FCC. The statute is the Telecommunications Act of 1996. And it's dealing with determining whether a cable internet provider is an information service or a telecommunications service.
Yeah, so the Communications Act or Telecommunications Act has sort of this broad dichotomy into two classes of services, right? You've got this category for telecommunications services, which are subject to a bunch of obligations like common carrier regulations, universal service, non-discrimination, right? Think like classic telephone service where they're not allowed to say, well, we don't like you, therefore you don't get a phone, right? Like they have to service everyone. They have to do rate regulation or be subjected to rate regulation, stuff like that, right? Those are the telecommunications services. And then there are the information services, which are much more lightly regulated. And yeah, so the question here is whether broadband internet is telecom or information. Is it a telecommunications service or an information service? And what does the statute say about this? How does it define these terms?
All of the definitions are in that first full paragraph on the top of 876.
Yeah, so telecommunications service is the offering of telecommunications for a fee. Telecommunications is the transmission between or among points specified by the user of information of the user's choosing without change in the form or content. So like you can imagine like a phone call where the idea is that you are conveying information by talking into the phone, and that is transmitted to the person at the other end of the line, and it's not transformed, at least not intentionally. Like if there's like a poor signal, like maybe you'll have, static or something, right? But it's not like you say one thing and they change it to something else, right? An information service, how does it compare to that? What's different?
There can be transformation, and there can be storing of data too.
Yeah, so we've got information service is the offering of a capability for generating, acquiring, storing, transforming, processing, retrieving, utilizing, or making available information via telecommunications, not subject to this limit of without change in the form or content, right? So is there overlap between those two definitions?
I think so, because transformation's not requiring, it's just part of the list.
Yeah, exactly, right? It doesn't say an information service is a service that transmits information while changing the form or content of it. It just says, you know, generating, acquiring, storing, transforming, processing, retrieving, utilizing, or making available information, right? So anybody have a sense of like what Congress was thinking when it defined information service in this way? Like what kinds of services did it have in mind? Is anyone in this class old enough to know what movie phone is?
Movie
No.
phone?
Yeah.
Is that where you'd call in and they would tell you like where a movie is playing at a certain time because
Yeah.
like the internet didn't exist?
Yeah. So like before the internet, here's how you would find out what movies are playing. One, in the newspaper, there would be like a page that had ads for all the different theaters, and they would have in tiny little print like the show times for all the movies they were playing. Or you could call Movie Phone, which had a phone number, I forget what it was, and it would just like play on this like loop, like what movies were playing in what theaters. And so you could call up and listen for a while, and eventually you would hear like, you know, the Cinemark 12 is playing, you know, Spider-Man 2 at 3:15, 3:45, 4:30, 5:25, right? You know, it was like that. And so it was this service that provided information over telephone lines in this really inefficient and annoying way, right? But it was before there was, you know, wide access to the internet, it was an extremely useful tool for getting access to information about movies. And that was sort of the kind of thing Congress was thinking about. Services that were offered through telecom, through phone lines, or through something like that, right? But that would provide specific information. And so instead of just being like this infrastructure service where you can call anyone you want over a phone line, it was providing specific information. And so, you know, they are doing that. They are offering a capability for generating, acquiring, storing, transforming, processing, retrieving, utilizing, or making available information via telecommunications, right? They're making available, offering, you know, storing, making, you know, et cetera, information that you can then acquire through telecommunications, which is calling them up and listening, right? And so so the question here is then, is broadband internet, which bucket does it fall into? What's the history of that question? What's the procedural history here?
You're talking about that they initiated a rulemaking proceeding that took about 2 years to finish?
Who did? The FCC?
Yeah.
So the FCC did a rulemaking. What did they conclude in that rulemaking?
That the broadband internet service providers were information service, not telecom service.
So they did a rulemaking and they decided we're going to consider this an information service. And that's something that, if we agree the statute is ambiguous, is like plainly within their power, right? So what's the problem?
The problem's that this was challenged by quite a few people, and then the judicial lottery put it into the Ninth Circuit. The Ninth Circuit had precedent, which was this AT&T versus Portland case, which held that cable companies were telecom.
Yeah, so like, just to be clear, step one is the Ninth Circuit says in AT&T versus Portland, broadband internet is a telecommunications service. It's like a phone line, right? And then step two, the FCC comes along and does a rulemaking that determines it's an information service, which is inconsistent with what the Ninth Circuit had said, right?
Yes.
And so then there are challenges to that wind up in the Ninth Circuit. And what does the Ninth Circuit do?
They just let stare decisis decide the case and reject the FCC interpretation.
Yeah, exactly. They say, we've already decided this. It is inconsistent with what you have done. Therefore, we vacate what the FCC did, right? And what's the what's the FCC's problem with that? I mean, one, they lost, but like, what's their argument that they shouldn't have lost?
Well, if they were first, they would have been entitled to Chevron deference, and they're wondering why they don't get it.
Exactly. That's the issue here, is do they get Chevron deference when they initiate a rulemaking that concludes that broadband is an information service like movie phone, not a telecommunications service like a phone line? Do they get deference for that even when some other court had said something earlier? And so if there was no agency at all, and this was just the second time the Ninth Circuit had a case with this kind of question, whether broadband is a telecommunications service, how would it decide that?
Oh, the same way they did in the circuit decision.
Yeah, sure, right? Like, we're bound by circuit precedent. Unless they rehear it en banc, or a few circuits let a single panel reverse or overrule a previous panel, but that's really rare. But in general, if the Ninth Circuit has held, a matter of circuit law, internet access service, broadband internet service is a telecommunications service, they are bound by that, right? What if that had come to a different circuit?
And then this would just be persuasive.
Yeah, and so, if the Second Circuit or the Fifth Circuit or whatever got a case about this, they would see the Ninth Circuit case, consider it persuasive precedent, right? And maybe agree with it, or maybe go the other way. And if they went the other way, there would be a circuit split that would be ripe for the Supreme Court to decide, right? And if the Ninth Circuit had previously done what it did here and said broadband internet is a telecommunications service like a phone line, and then a second case came before the Ninth Circuit and they said, well, we're bound by circuit precedent, and then it got petitioned to the Supreme Court and the Supreme Court granted cert, what kind of deference would the Supreme Court pay to what the Ninth Circuit had said the first time?
They're not bound by that circuit.
Yeah, nothing, right? The Supreme Court does not care at all what the lower courts said before. And so that would be a question reviewed de novo because it's a question of law. So that's how it would play out if there was no agency here, but we do have an agency here. So what does the Supreme Court say? What is the level of deference that the courts should apply? Like, should the agency get Chevron deference?
I guess I'll keep going then. Yeah, Chevron.
Yeah, are the rest of you like there still?
Yeah.
Yeah. So it's my understanding that the agency gets deference over the lower court decision, even when the lower court decision is in conflict with the agency's decision.
So is that true in the Ninth Circuit? Is that true in the Supreme Court? Is that true in both?
I believe it's true for the Supreme Court. I don't think it's true for the Ninth Circuit.
Well, it would be a little strange if the Supreme Court had to be more deferential to the agency than the lower court, right?
Yeah, the Chevron framework is supposed to apply for all levels.
Yeah, right? Like, the outcome of this case is that the court says both the Supreme Court and the Ninth Circuit should apply Chevron deference, right? That what the Ninth Circuit did was wrong. The Ninth Circuit, in saying, no, wait a minute, we already decided this, therefore you're not allowed to overturn us, was wrong. Why? What's the reasoning there?
It kind of goes back to just the Chevron principles that the agency is supposed to be the authoritative interpreter. And so just because the court was first doesn't displace the power that has been set aside. for the agency.
And so like if we, you know, one of the points that we've mentioned a couple of times now is like different ways to interpret Chevron, right? Where Chevron itself talks about the reason for deference being when it's ambiguous, that is an express delegation of authority from Congress to the agency to decide, to make a policy choice, right? But like another way of interpreting Chevron, which you know, is sort of what a couple of the articles we read toward the beginning of the Chevron unit mentioned, was that maybe it's sort of a prudential rule to resolve ambiguities when we don't have a better reason to resolve them in one direction or another, right? Or it's sort of a default rule of statutory interpretation or a canon of statutory interpretation. This is consistent with this idea that Chevron is about power, that like ultimately the power to make the choice is the agencies, not the courts, right? That Congress says, you know, defines telecommunications service and defines information service in these broad, ambiguous terms. And that when it does so, it is expressly, intentionally giving the agency the power to make a policy choice. And so why would that mean we can go ahead and ignore what the court had said earlier?
Well, you can't always ignore what the court has said. If they decided that it was an unambiguous interpretation of it, then the court's decision still applies. It's just when there's multiple plausible interpretations, it's not been decided definitively when the court weighs in. They've just provided one possible option.
Mm-hmm. And they've just provided one possible option, but still, like, the same is true like when the Ninth Circuit is interpreting the statute when there is no agency at all, but then we still say the court is bound later, right? So why would we not do the same thing here?
I think it just goes back to the court just labeling the agency as the authoritative interpreter. And if they're authoritative, they can come in and decide that later.
Yeah, they're allowed to change their mind, or they're allowed to impose a new policy even if the previous policy was different, right? And the same, that is true if the previous one was from the agency, like in Chevron itself, right? But it's just as true if the previous policy was kind of a gap filler from a court. Like if the court's like, well, this is ambiguous, we're not sure, we think the best interpretation is X, and the agency comes along and says, no, we're going to decide that it's Y, right? That's something they have the power to do under Chevron. And so just like in Chevron itself, just like in FCC versus Fox, those are cases where the agency shifted between permissible views. This is one where the previous view was the court, not the agency, but the agency still has the power to shift between them if they're both in the universe of possible views. And so that's why if the court said it was unambiguous, it still holds, right? It's like Chevron step 1 asks if the statute is ambiguous or not. If the court said it unambiguously meant telecom service or information service, then that's sort of a conclusion that on Chevron step 1, Congress has been clear, so there's no ambiguity to fill in, right? But like the respondents made an argument here that Chevron shouldn't really apply because the agency's interpretation was inconsistent with that past practice. And so this is sort of a like bait and switch almost. How does the court respond to that?
Yeah, so under the Chevron step 2, you'd still be looking to see if it was an arbitrary and capricious decision. And so it would just basically be not reasonable, potentially, for doing that bait and switch.
Sure, right? So it's relevant under the Chevron analysis where the agency has to have some reason for changing its mind. And they probably have to say what that is. This is sort of top of 878. bottom of 877, top of 878. Agency inconsistency is not a basis for declining to analyze the agency's interpretation under Chevron. Unexplained inconsistency is at most a reason for finding everything they've done arbitrary and capricious. But if the agency adequately explains the reason for a reversal, just the fact that it's reversing itself is not a basis for striking down what it did. It can still be a reasonable decision under Chevron, even if the agency is doing a 180. So what happens if an agency goes through rulemaking and adopts an interpretation, and a court comes along and says, like, think about like AT&T versus Iowa Utilities Board. This is unreasonable under step 2. Can the agency go back and adopt a different interpretation? Or is it stuck with what the court said? Like in Iowa Utilities Board, if the Supreme Court had said, no, this rulemaking by the FCC is wrong because it's unreasonable under Chevron step 2. Like, we agree it's ambiguous whether, caller ID is a network element or not, and but the rule is unreasonable, and so we are going to hold that caller ID is not a network element. Could the FCC come along and do another rulemaking and say, no, actually caller ID is a network element?
I think so. The trick would be it has to be ambiguous, like you were saying, and they have to follow the proper procedures to get to that rulemaking, to have that Chevron deference. But it has to still be reasonable at the end of the day, so you can try again to get to reasonable.
And do the others agree?
Yeah, I do.
So what if the court said something like, we agree this is ambiguous, but clearly any interpretation that said caller ID is a network element would be unreasonable?
Well, then trying again is not going to get a different result. I mean, there's nothing to stop them from, continuing to repeat their efforts.
And just losing over and over again?
Yeah.
Yeah. I mean, it's sort of a way of saying, like, the court would basically be saying, we think this statute is unambiguous, that it doesn't cover a caller ID, even if it's ambiguous in other ways, right? But yeah, I think that's exactly right? Like, if the Supreme Court said, we think that this statute is ambiguous, but what the agency did was unreasonable, then they can try again, even if the court adopted an interpretation to decide that case at the time. Because otherwise you would get these weird results where if the court had to interpret the statute and then that interpretation was locked in, the agency can't like update it to comply with evolving technology and political change and things like that, right? Okay, so that's the theory here, right? This idea that if we take Chevron at its word, Chevron is about a delegation of power to the agency, not the court, and therefore the agency is allowed to change, just like the agency is allowed to change its mind, it can adopt an interpretation even when a court has adopted an interpretation. We've got another Scalia dissent. What's he concerned about now? What's his complaint now? Which is, by the way, it's kind of an amazing lineup, right? Because it's a Scalia dissent joined by Souter and Ginsburg, who are, as far apart on the court as possible.
With Thomas writing the majority opinion too.
Yeah, this is a case with a weird lineup.
Yeah, I mean, Scalia is basically saying this is a way to patch up problems from some prior cases by giving more flexibility to the agency so they're not locked in when courts decide things not entitled to Chevron deference.
And
But
specifically kind of like he's still pissed about Mead, right?
Yeah.
Where Mead was the case about, you know, we have to decide in each case whether or not we're going to apply Chevron in the first place. And if it's not a notice and comment rule, maybe we don't apply Chevron. And so Scalia was concerned that Mead sort of eviscerated Chevron and created more de novo review. And now we're kind of trying to fix that in a way that is not really getting at the real problem. But what's the problem with this fix?
he thinks it's unconstitutional because it allows the agency to trump the court's decision.
How's that unconstitutional?
Separation of powers, I think it's supposed to be. I think the
mean-
judiciary has the power to decide things finally, and so if an agency can overturn that, it's taking away their power as a court.
So Article 3 courts under the separation of powers have basically the power to say what the law is, right? The power to interpret the law. And this says that the executive branch can just ignore that or reverse them or something, right? What do we think? Do we agree with the constitutional claim here? Actually, let me come back to that question in a minute. So practical upshot here. If you're an agency now, how do you know if you're allowed to ignore an agency decision or a judicial decision and enact a rule that's inconsistent with a past case? Like, how do you know if this falls into the Brand X bucket or if this falls into the bucket of you're not allowed to do it because the court has already decided?
The type of deference you're entitled to. I thought Chevron deference, you get the Brand X, but if it's Skidmore, you don't.
Well, I mean, true, but if you have go ahead.
Is it more whether the court decided whether the interpretation was ambiguous or whether the language of the regulation is ambiguous?
Yeah, so if it's the court doing notice and comment rulemaking to interpret its own organic act, it would get Chevron deference regardless, right? But then the question is, did the court decide it was ambiguous or not? And in practice, what is that going to mean in terms of the amount of discretion the agency has? Is it going to have a lot of power or not very much?
I would assume a lot because most statutes are ambiguous in this field.
I mean, a lot of statutes are ambiguous, right? And clever lawyers can always point to something that is going to be the basis of claiming there's an ambiguity. And how often are you going to have courts that say, I think this statute is ambiguous, or I think this statute is unambiguous?
Not very often.
I mean, in a Chevron case, the court will probably may say clearly, right? Like in a Chevron case, when you have this two-step process, the court may step through the steps and decide, well, under step one, I think this is ambiguous and therefore under step two, reasonable. Or under step one, I think this is unambiguous and means X, right? But the kind of case that we're talking about here is one where we don't have an agency interpretation in the first place, because we have a court deciding it before the agency makes any decision, right? And so those are the kinds of cases where the court is just going to come to its best interpretation of the statute without walking through the Chevron framework. And so the court may never say whether this is ambiguous or not. And so the practical effect here is it's going to give the it's going to give the agency coming second a lot of power to say, well, we think this court thought it was ambiguous, right? And therefore we can do a new rule. it's relatively rare that the agency is going to read a court decision and say, well, we think they thought this was unambiguous, because that will limit their own powers. So if the party that's deciding whether the court thought it was ambiguous or not is ultimately the agency, they're going to be pretty free to enact new rules. But that might be inevitable because it, as the court points out, it would be really weird if the correct interpretation of the statute depended on whether the agency or the court went first, right? And so if we're going to say under Chevron, agencies have a lot of power here, it's consistent to say they continue to have a lot of power, even if the court has already said something, right? But then we get, so as you pointed out, Justice Thomas wrote Brand X, and now earlier this year in Baldwin, he thinks it should be overturned. Just a couple of questions on this before we move on to our. So this is a case about the tax code, where in 1992, the IRS had interpreted this deadline. And then in 2011, petitioners mailed their paperwork to the IRS. And then in 2011, later, a couple months later, they adopted different interpretation through informal rulemaking. And the Ninth Circuit deferred to the informal rulemaking, meaning notice and comment rulemaking regulation that they adopted later in 2011. And so this request to obtain a refund was too late. You don't get your refund. So what is Thomas's critique here?
It's kind of twofold. He wants to go back and reevaluate Chevron itself, which is pretty big undertaking. But then if he can't do that, he wants to go back and reevaluate Brand X.
Yeah, so first, Chevron's wrong because Constitution and APA and stuff, right? And then second, even if Chevron isn't wrong, Brand X is wrong. And so setting aside the Chevron critique, just the Brand X critique, what is the critique exactly?
He's kind of returning to Scalia's Article 3 constitutional concerns.
And so Thomas argues that courts have a duty to give effect to the will of the legislature and therefore the law, but Brand X directs courts to give effect to the will of the executive. And means that courts can't follow their own precedent. So what do you think of that argument?
I think it raises a fair concern, but at the same time, the Brand X decision was trying to address some odd results that can happen where whoever's first kind of decides the interpretation.
Mm-hmm.
So there's tough balancing there.
Other thoughts? Anyone? Ms. Janine, Ms. Kuntz, Mr. Willie, anyone else in the class?
To me, it seems like he's more fine with Chevron than Brand X. Like if he wants to tear apart Brand X completely, because he talks about how even though it does fill the gaps, that the constitutional gaps from Chevron, he says it went way too far. So.
Mm-hmm. And so if are there any other areas where you have federal courts that are like deciding a question of the law, but like are subject to being overturned by someone else later, and then they follow the new thing rather than their old interpretation? I mean, I guess if Congress changes the law, clearly, but that's sort of different, right? That's a new law.
I think other than Congress, not really.
So what about like diversity cases where you have a federal court deciding a question of state law? So if you have like the First Circuit, which is the Federal Court of Appeals that covers New Hampshire and Massachusetts and Maine and Rhode Island and Puerto Rico, like if there's a diversity case in the federal courts in New England that goes to the First Circuit, and the First Circuit has to apply like Maine state law, and there's no authoritative decision of the Maine Supreme Court on this, and so they say, we think the most likely outcome is the Maine courts would say X, and therefore the outcome of this case is X. Can the Maine Supreme Court come along and change that? Not in that particular case, but like as their interpretation of Maine law?
I believe so.
Sure. They're not bound by what the First Circuit said, right? Like the Maine Supreme Court is the ultimate authoritative interpreter of Maine law. And so, you know, if the First Circuit says we think under Maine, you know, in a tort case, we apply, the Supreme Court has never said in Maine whether it's comparative negligence or, you know, whatever the other one is. I don't remember this tort stuff, but like, you know, we think that the Maine court is most likely to adopt contributory negligence instead of comparative negligence, right? And then later the Maine Supreme Court says, oh, we've never authoritatively decided which version of negligence law we're doing. We are going to adopt comparative negligence, even though the First Circuit thought we would say contributory. If later the First Circuit has a different case involving Maine law, should it apply its precedent or should it apply the new Maine Supreme Court case?
The new Maine Supreme Court case.
Sure, right? Because like when they decided the first time, they didn't have the authority to decide what the state law was. They were just sort of taking a guess as a gap filler because they didn't have an authoritative decision. And that's kind of what federal courts are doing when they interpret an ambiguous statute where the agency has the power to interpret it. They're kind of just taking a guess or doing a second order gap filling. And so if that's right, if Chevron is right that Congress has delegated this power to the agency, it seems to me that Thomas is quite wrong, that it's entirely reasonable that the agency would continue to exercise that authority even once the court has interpreted the statute, because the court was just kind of doing sort of a second best gap filling. But that assumes Chevron is right. If Chevron is wrong because the Congress is not allowed to delegate in that way, as we'll discuss later in the term, then that's a problem for Brand X. But if we believe Chevron is right, then Brand X seems to me to be inevitable, although, you know, Justice Thomas is on the court and I am not. So, you know, the court may change its mind on that. Does that make sense? So questions on that before we turn to our?
I have just a quick question. So it seems to me like it's really kind of following the ball of like legislative authority and like the delegation of it all. And so that's one of the reasons that the ambiguity question is defining, is because if it's unambiguous, then the legislative ball kind of doesn't pass to the agency.
Exactly. They haven't delegated anything.
So the other circumstance I could see that being applied would be if the court is answering the question on a constitutional ground, because if they answer it on a constitutional basis, then that seems to foreclose any legislative delegation. Is that fair?
Do you mean like if the court said, this is, you know, delegation is unconstitutional, or do you mean if the court said, well, this thing may be ambiguous, but like the interpretation that's consistent with the Equal Protection Clause is the one that says, you know, immigration law can't discriminate on the basis of national origin or something?
Yeah, well, I think both, right? I think the bigger question is like, is the delegation constitutional, which is the whole is Chevron legit question that we'll apparently be going deeper into.
Yeah.
But if in this analysis the court says it's unreasonable because essentially it's unconstitutional, then that seems as though the agency wouldn't be able to go back and change it because it's now been decided on a constitutional ground, which the legislature has no ability to affect.
I think that's right, with one small caveat, which is that if it's sort of like the case we discussed about using constitutional avoidance as a way of interpreting it in step one. And so if the court said, you know, any interpretation that did X would be unconstitutional, then yeah, that's something the agency couldn't later come back and do, right? But if what they did was say, you know, yes, this statute is ambiguous. We think that the interpretation the agency adopted here is unconstitutional, but kind of leaves open the possibility that a different interpretation within the realm of the ambiguity would be permissible, then it would be okay. So like something like, is this an information service or a telecommunications service? Maybe not, right? Because that's sort of a binary choice. But if you could imagine something like, you know, an environmental regulation about what is the permissible amount of, you know, arsenic in the water supply or something, right? If the agency said the permissible amount is 0 and the court said, well, it turns out that's impossible and therefore it's unconstitutional because it violates due process to say it's not legal to be a water producer or something, right? It might still be fine to set it at 10 or 20 or 30, depending, right? It sort of depends on what exactly is the constitutional problem. But yeah, if the court says, you know, any interpretation that means, you know, this would be an information service is unconstitutional, then yeah, they can't do that.
Thank you.
Does that make sense? Is that helpful? Other questions? Okay, so thank you, Ms. Deneen, Mr. Gluck, Ms. Kunson, Mr. Willie. I guess I should take down the screen share. Our last Chevron topic is what happens when agencies are interpreting ambiguous regulations as opposed to ambiguous statutes. This is called Auer deference, or sometimes it's called Seminole Rock deference. Auer deference is after the case Auer versus Robbins, which is our first case, for which we have Ms. Brahman, Mr. Lee, Mr. Schmitz, and Ms. Swin. Are you guys around?
Yep, I'm here.
Hello.
Yep.
So what's going on here? What's the setup for this one? What's the regulatory context?
Well, it looks like it's the Fair Labor Standard Act. It defines kind of like who can get overtime pay, but then there's also like exemptions of where overtime pay wouldn't apply to the employee. And in this case, there's police officers, sergeants, and lieutenants. They bring a suit against the St. Louis Board of Police Commissions, and they're claiming their own overtime pay, while the St. Louis Board is saying that they aren't because they're under the exemptions.
So we've got another overtime case where, again, we've seen this a couple of times only really in overtime cases, although, you know, it's sort of not the typical process here, but we've got a private lawsuit by employees against an employer that depends on an agency interpretation. And what's the agency involved? You may have said this, but I'm just clarifying one more time.
I think it's the Department of Labor.
Yeah. And so what are the actions that they have taken here?
Who's taken?
That the agency took.
the agency, they're interpreting their regulation, because as you said, it's between private parties. So the agency, they write a legal brief that explains what their exemptions are meant to be, and they submit that in a amici brief, I think.
Yeah, it's a little bit weird because it's not like a standard rulemaking, right? It was a brief they submitted to the Supreme Court, basically at the court's invitation. And what did that brief say?
I think that what the brief said is, because in the exemptions are basically saying like it applies unless the employer can deduct your pay for quality or quantity, but then the Department of Labor is further qualifying that exemption by saying if that deduction is based on like an infraction of safety violations or some type of policies, then that doesn't count. So you'd still not be eligible for overtime pay if that's the only type of deduction there. So they're further interpreting what the exemption policy is.
So I think I have framed this in a way that is too confusing. So let me step back for a minute, right? So we've got a statute. What does the statute say? Like the question here is, do these police sergeants get overtime pay? What's the statutory text?
Is that just the exempts bona fide executive, administrative, or professional employees from overtime pay requirements?
Yeah, exactly. So the Fair Labor Standards Act says you have to pay overtime to a bunch of employees. You know, this is sort of the statute we saw earlier where it like listed a bunch of categories of employees. It was like people who work in taxi cabs and people who work in movie theaters and stuff. And one of them is bona fide executive, administrative, or professional employees, which sounds super vague, right? And so what did the agency done to interpret that in the first instance?
I think they're like defining the scope of it, like let's see. Oh, is that the salary basis rule?
Yeah, so they issued a rule, right? Like they did notice and comment rulemaking, they promulgated regulations. These are at 29 CFR 541.1 sub F and 541.2 sub E and 541.3 sub E. This is part one of the opinion on 915 and 916, right? So statute is super vague. Agency issues rule. This is sort of a standard normal thing in administrative law, right? And their rule said, if you have a salary basis above a certain level, you are a bona fide executive, administrative or professional employee. And what is a salary basis under the rule?
The salary basis is if it receives a pay period on a weekly or less frequent basis, predetermined amount constituting all or part of compensation, which is not subject to reduction because of variations in quantity or quality of work performed.
So if you just get paid a salary and that amount can't be reduced if your work is bad, right? Then that's one of the ways they tell if you are a bona fide executive, administrative, or professional employee, which kind of makes sense, right? Like, you know, if you think about like, you know, an executive at a company gets paid a fixed amount of money a year, you know, they might get a bonus at the end of the year, but they don't get like, well, you only work 25 hours this week and therefore you get less money this week, right? You get paid a fixed amount. And that's how most professionals and executives and administrative type employees get paid, as opposed to like hourly workers who get paid an amount that is not fixed on a weekly or longer basis and is subject to reduced pay for quality or quantity, right? And so that's the regulation they have promulgated. why doesn't that just answer the question of whether these sergeants get overtime?
Because the officers say that technically they don't meet that standard because their pay could be reduced if they have any kind of an infraction related to the quality or quantity of their work.
Yeah, the police in St. Louis, I think it was, have a bunch of things in their manual that they can be fined for, you know, rule violations, right? And so their argument is, well, you know, the rule is clear. We don't count, we don't fit within that rule, and therefore we are not bona fide executive, administrative, or professional employees, and therefore we get overtime. And so 2 questions at issue in this case. First is whether this is a reasonable rule under the statute, right? Which is the normal Chevron question. What's the dispute about that?
So you're asking what's the dispute about the salary basis exemption?
Yeah, we have just a challenge to the rule in the first place, right? Like the challengers here say this rule is invalid.
I think I was trying to talk about it earlier. I think it's with like, they're saying that you're exempt from it if you can get your pay deducted, but there's an exception to that that says that if it's for like an infraction of like employment policy, then that doesn't count as a deduction for quality or quantity.
Well, so, but that's about like, what does this rule mean and how do we apply this rule, right? But first, like just on the question of whether this is a valid rule in the first place, what's the argument that the rule is invalid?
Wouldn't there be an issue with saying that someone is a salaried employee and they wouldn't be eligible for overtime when really there's not really much of a distinction? It's just how you're paid and not really the kind of work that you're doing. Like then you can just preclude people from getting overtime by just making them a salaried employee. That's how I read it. And I'm not really sure.
So pointing to where in the opinion here?
Just like generally like the issue in the rule where it would be kind of an arbitrary decision by saying if someone is salaried, then they're not eligible for overtime. I would see that as just problematic from just a general.
Just as an interpretation of bona fide professional, executive, or whatever, administrative?
Mm-hmm.
Mm-hmm. I mean, maybe. I mean, I don't see that in the opinion unless I'm missing it somewhere, right?
Oh, no, so I was just asking the question is like, would that be a consideration for them?
I mean, you could make that argument to the court. The argument would be something like, when the statute says bona fide professional, administrative, or executive, that sounds not about how you're paid, but about what your role is. And so it's an unreasonable interpretation under hard look review because like how you're paid doesn't say anything about, you know, whether you're a professional or an executive or an administrative employee, right? Like, you know, if you're a manager, but you're paid hourly, you're still an executive, right? Or like, think about somebody like an emergency room physician, right? Like emergency room physicians are paid hourly. But maybe we wouldn't say that they're, you know, normal hourly workers who get overtime because of what they're doing, right? So that's an argument you could make, definitely, right? But there's an argument that's made here that is specifically about applying this rule to public sector employees. Sorry, someone was about to speak.
Professor, they bring an as applied challenge. They're saying it's unreasonable. It's an unreasonable interpretation of the exemption for no disciplinary deductions element of the salary basis test as applied to the public sector employees.
Yeah, so this is sort of bottom of 916, top of 917. The argument that as applied to public sector employees, this is unreasonable because what? Like, why would it be different with them?
Because they're pretty much impossible to fire. Like you have, like the only way you can discipline a public sector employee is to reduce their pay. Like everything else is like precluded.
Which is,
barring a
not
big,
really
long
true,
process.
but. Sorry, go ahead.
Just barring like this big, long process. Like it's kind of, they're saying it's only the only reasonable way to deal with public sector employee malfeasance.
Yeah, they say not only is it sort of, maybe the only reasonable way to do it, but it's a necessary way to do it because, like, you have both normal employee-employer issues here, but also the purpose of serving the public, right? And therefore, the employer has a duty to the broader public to enforce rules. And the only way to do that here is through some kind of, fine or reduced pay or something, right? And what's the court's response?
Are you asking about the district and circuit court or the Supreme Court?
The Supreme Court.
So the Supreme Court agreed with the other courts, and they said that it wasn't ever exercised, that really ever, as far as the pay being deducted for infractions, and so they couldn't use that to say that it was being used against them in that way.
Well, but just on the challenge to the regulation, like as applied to public sector employees in the first place, right? Like this argument that this rule is unfair when it comes to public sector employees, because public sector employees have to have the possibility of reduced pay, and therefore this can't be the right test for them. What does the court say?
The court just applies Chevron and says it's a reasonable interpretation that the agency has taken. The respondents have a reasonable interpretation, but the court won't choose between them.
So that first full paragraph on 917, because Congress has not directly spoken here, we must sustain the secretary's approach as long as it's based on a permissible construction of the statute, citing Chevron. While respondents' objections would perhaps support a different application of the test for public employees, we cannot conclude that they compel it, right? So it's reasonable, we're gonna affirm it therefore. And so under Chevron, the rule survives in the first place. And then we get to the other part of this opinion about the agency's construction of the regulation. So what's going on there? I mean, the regulation says you're part of this exempt overtime group if you're paid a salary that is not subject to reduction for variances in the quality or quantity of your work. Sounds like that should mean that the sergeants are not entitled to overtime.
I think there is a difference.
Or sorry, that they are entitled to overtime, sorry, because they might lose pay because, if they violate the rule, they can be fined. Anyway, sorry, go ahead.
Oh, I think there's difference between a theoretical possibility of the deduction and actually vulnerable to this deduction.
Yeah. And so the city had argued, okay, maybe theoretically we can reduce your pay, but in practice, that's a hypothetical that never happens. And so the city's argument is, even under the agency's rule, these people are not really subject to pay reductions. Therefore, they really are salaried. Therefore, they don't get overtime. And the court says, well, we don't know. So let's ask the agency. What did the agency say?
The agency agreed with them. They qualified the subject to as a practical matter, they would have deductions in pay, and there'd be a significant likelihood of those deductions.
Yeah, so the labor secretary files an amicus brief that kind of takes a middle ground, but basically says, we think the salary basis test in our rule means that you are subject to reduction if either there's an actual practice of making those deductions or if you have a policy that creates a significant likelihood, right? And so what's the court do? How does the court take that amicus brief? What does it do with it?
So I think the court said the salary basis test is a creature of the agency, so his interpretation of it is controlling unless plainly erroneous or inconsistent with the regulation.
Yeah, this is that first sentence on 918, and this is sort of the holding of the case in one sentence. Because the salary basis test is a creature of the secretary's own regulations, his interpretation of it is, under our jurisprudence, controlling unless plainly erroneous or inconsistent with the regulation. So the Secretary of Labor wrote this regulation, and therefore it is the secretary's interpretation of it is controlling unless it just seems out of whack, right? And in this case, that means that the sergeants and the lieutenants don't get overtime pay. So implications of that. One, it's a little odd that the agency's view came in an amicus brief filed at the invitation of a court. Should that matter here? Should we care that this came in an amicus brief, not in either an interpretive rule or another notice and comment rule or a series of adjudications by the agency or something?
I mean, they could be concerned that it's like post hoc rationalization. They're just interpreting it now and they never had that intention in mind in the first place. And they're just saying what they think of it in the current situation.
Yeah, that would be the argument against it, right? This idea that it's not an honest interpretation of what the agency meant when it enacted the rule, that it's sort of after the fact post hoc rationalization. But the court says, no, we don't care. Why?
It seems like basically it's just because the secretary has the power to do so. It's his own regulation and he can construe it as he wishes.
So that's sort of the Chevron theory, right? Is that like, this is something that the agency had the power to decide in the first place. And they did so through notice and comment rulemaking. Now they may have been a little vague in the notice and comment rulemaking, but there's no reason to suspect that anything is going on here that would be a problem, that there's no reason to suspect the interpretation is not their fair and considered judgment. And I mean, kind of last sentence in the opinion, very top of 919, a rule requiring the secretary to construe his own regulations narrowly wouldn't make any sense because they could just write them more broadly to begin with, right? So step back for a second and think about the different rules here. So if we have an agency that has an ambiguous statute and goes through notice and comment rulemaking and publishes a rule, what's the level of deference that the court will pay for that, to that?
If they go through notice and comment rulemaking, I mean, isn't that the hour deference? So the court's going to defer to them because of their expertise.
Sorry, not like hour is about interpretations of regulations, but just like the normal rulemaking in the first place. So you've got like, you know, Congress passes a law that says, you know, the EPA shall promulgate rules to set the permissible level of, you know, the permissible temperature of water discharged into this waterway. And the agency says we set the permissible temperature at 85 degrees Fahrenheit. What will the court do? if it's
Well,
about,
they would do, I mean, wouldn't they apply Chevron deference?
yeah, they apply Chevron deference, right?
Yep.
If an ambiguity becomes clear in the regulation and the agency issues an interpretive rule to clarify its interpretation of the statute, what level of deference does that get?
That's the hour deference then, wouldn't it? Because they're interpreting their regulation.
Well, not of the interpretive rule. So think about a case like the diagnosis for the lung workers in the mine safety case, where they issued a rule that said this gets that you have to report diagnoses within 10 days. And then they issued an interpretive rule that says, we think it counts as a diagnosis when it hits level 38B on the X-ray or something. Under Mead, what does that get? So Mead says you don't get Chevron if you haven't gone through notice and comment. So what do you get instead?
Right, then you get Skidmore.
Yeah, Skidmore deference, which is not very deferential, right?
Mhm.
If instead, though, we have an ambiguity in the regulation and the agency issues an interpretive rule to clarify its interpretation of its own regulation, what level of deference does that get?
I mean, in that case, then it sounds like it'd be hour deference.
Yeah. And how does our deference compare to Chevron or Skidmore?
I think hour is much more deferential than both of them.
Yeah, hour is basically the most deference you can get. Like there are empirical studies on this that show that like if you're applying hour, agencies win 91% of the time, which is way more than under Chevron, way more than under Skidmore. And that's sort of intellectually incoherent, right? Because under Mead, if they interpret the statute in an interpretive regulation, we'll only give them Skidmore deference. But under our, if they interpret their own regulation, we give them really high deference, right? And so, note, by the way, our is a unanimous Scalia opinion, right? Not controversial at the court. And then over time, we begin to get some doubts on this. Just a couple of questions on this before we'll be out of time. And so we'll do Kaiser v. Wilkie next time. But Talk America is another telecom case where the court is deferring to an FCC interpretation of its own regulations. And Justice Scalia, who wrote our, concurs, but expresses some skepticism, right? What's his concern?
Basically that our deference or Seminole Rock deference, whatever you want to call it, is like completely untouchable.
Because why?
So I guess he's kind of talking about the abuse, right? In that an agency can just issue this super broad rule and then can use the Seminole Rock deference to interpret that rule as being ambiguous. And then you have absolutely no ability for the courts or really the legislature to like step in unless there's like another subsequent act of Congress that eliminates the ambiguity.
Yeah, so this was sort of the thing we were concerned about when we talked about, you know, interpretive rules not having to go through notice and comment rulemaking way back in the 553 cases, right? Is that the agency can just write a vague regulation and then under our say what means whatever the hell they think it means, right? And they get basically infinite deference. But Justice Scalia was a big proponent of Chevron. So is this something where he's rethinking Chevron, or does he not see this as sort of a natural corollary of Chevron? Like Chevron itself gives the agency a bunch of power, right? So why is it a problem if we give them a bunch of power to interpret their own regulations if they had the power to issue the regulations in the first place?
This is where he's comparing the legislative process. So in Chevron, the power is coming from Congress enacting the statute, where the initial step is Congress enacting the statute, and that's politically accountable. Whereas in our, the initial step is the agency enacting a rule, and that's not politically accountable.
Well, I mean, it's kind of politically accountable in the sense of like, it's an action of the administrative agency, which is reports to the president, right? But yeah, that we have this, like in Chevron, we've got Congress enacting an ambiguous statute and then the agency resolving it. In our, we have the agency enacting an ambiguous regulation and then the agency resolving it. And so we don't have the separation there that we do in Chevron, right? And so when we're applying Chevron, we've separated the legislative and executive functions, or we've separated the sort of rule, like the first line of delegation to the agency that gets that delegation. But when you have an agency that is issuing this imprecise rule, it's basically delegating resolving those ambiguities to itself in a way that is very hard to review. And so we've got a separation of powers problem. And what is the effect of that in terms, like, what is the incentive then if you're an agency?
Issue ambiguous rules.
Sure, write some really ambiguous rules. And so if we give deference to the agency interpretation of its own rule, we're just encouraging them to be as vague as possible, which frustrates the entire point of notice and comment rulemaking, right? Like notice and comment rulemaking is designed to give the public notice of what the rules are so they can provide useful feedback and so that the court can evaluate if that policy decision made sense. And here the court is saying, if they can just be really vague in the rule, then they don't really have to provide the real notice that would be necessary for people to provide useful feedback. They can just do a really vague rule and later fill it in when it's too late to provide that feedback. He also notes at the very end, there are some benefits here, right? That our provides some certainty and predictability, which is consistent with agencies winning 91% of the time. But the upshot of this opinion is it is part of a line of cases that are beginning to have doubts about our deference. And those are going to culminate, or at least culminate for now, in Kaiser v. Wilkie, which we will discuss beginning next class. But for now, thank you, Ms. Rahman, Mr. Lee, Mr. Schmitz, and Ms. Swin. Any questions on that?
What's the reason why it negates notice and comment? So they just have a really vague rule and then they fill it in later, but why does that obviate notice and comment?
Because if the notice is notice of the really vague rule, people might not know what it will really mean in a few years when the agency interprets it. And so, like, you know, if they say, like, if the notice of the proposed rulemaking is like, hey, we're going to require you to report a diagnosis within 10 days, but they don't say what a diagnosis is, then like the comments might be like, well, that's not a reasonable interpretation of diagnosis because, you know, that's going to be too many cases, or we won't really know, the test results won't be back in time or something, right? Mm-hmm. Whereas if they said, instead of saying like, you have to report within 10 days of a diagnosis, if the notice of proposed rulemaking was, you have to report within 10 days of a diagnosis, and a diagnosis includes, you know, a conclusive test result or the following symptoms which should give rise to an inference that you have the illness. And the response was, well, but those symptoms are completely consistent with this other thing as well. And so you should just wait until we have the conclusive test results. That's the kind of thing where the agency will get those and will be like, oh, okay, let's change our rule, right? Versus if you can just be really vague in the rule and then later interpret it to mean symptoms are enough, it's too late at that point to provide the comment.
Mhm.
Make sense? Cool. Other questions? Okay, I'll see everyone on Wednesday. Have a good Tuesday. Vote if you haven't yet. You can register day of in New Hampshire. If you are not registered, you can still go vote if you are qualified. And if you're going to do that, look up all the paperwork you're supposed to bring. But so see you then.
You can also sign a sworn affidavit at the polling place.
Absolutely. If you don't have the proper paperwork, you can do it all by affidavit there.
Thank you, Professor.
Thank you.